Hey, so this is my appeal. This is probably one of my best arguments. It's long, so I'm going to not read all of it. Introduction. The legislative intent interpreted by the people of the state of California is to protect children from harm or future harm. The people, in quotes, understand this harm to be abuse defined by physical or extreme emotional detriment. A sort of disconnect exists between the legislature, juvenile court, child welfare department, and the people of the state. The only harm to ever occur to all of the appellant's children ever has been directly caused by the Department of Child Welfare. Despite disagreement to the re-education voluntary mandate to release the appellant's child, an attempt to services was completed. Parenting class, several drug screens, and behavioral health was contacted and completed. The appellant could not do all the services unless she admitted to the service provided that drugs were used within the last year. The programs offered to the appellant not only would have required a false self-incrimination of guilt, but the drug courts violated HIPAA rights and all moral penumbrum rights existing between the parent and child. In these drug court sessions, children accompanied all these enrolled parents in front of the judge and attorneys and discussed drug test results and progress. Absolutely disgusting. Absolutely disgusting to belittle a parent in a community in such a manner, preconditioning a child to social status before they are even aware they have one. These are the professionals this court relies on for fiduciary facts. The appellant was denied erroneously to speak and be heard in the lower court. The appellant from this point forward will define speak as to be heard, cross-examine, submit new evidence, question counsel, induce discovery, or be represented. The advocacy group, currently that is called counsel to the defendants in the juvenile court, do not disclose their main purpose of making the process more efficient, as stated in the dependency handbook. The people of the state understand representation as one that is on their side, which is not the case. Attached to this argument will be a spreadsheet with highlighted dates and occurrences your honorables may reference for a clear and concise outline of events. The purpose, legislature intent, 19 WIC, establishing programs and services designed to provide protection, etc. to children deemed by the juvenile court or agency to ensure that the rights or physical, mental, or moral welfare of children are not violated or threatened by their present circumstances or environment. Where a statute is ambiguous, we may consider a variety of intrinsic aids, including legislature history, the statute's purpose, and public policy. That's a citation. People versus Gonzalez. We must select the construction that comports most closely with the apparent intent of the legislature, with the view to promoting rather than defeating the general purpose of the statute, and avoid an interpretation that would lead to absurd consequences. People versus Coronado, 1995. As in any case involving statutory interpretation, our fundamental task here is to determine the legislature's intent so as to effectuate the law's purpose. The well-established rules for performing this task require us to begin by examining the statutory language, giving it a plain and common sense meaning. That's all citation. We do not, however, consider the statutory language in isolation. Rather, we look to the statute's entire substance in order to determine its scope and purposes. Also citation. That is, we construe the words in question in context, keeping in mind the statute's nature and obvious purpose. We must harmonize the statute's various purposes. We must We must harmonize the statute's various parts by considering it in the context of the statutory framework as a whole. That's all citation. If the statutory language is ambiguous, then its plain meaning controls. If, however, the language supports more than one reasonable construction, then we may look to intrinsic aids, including the ostensible objects to be achieved and the legislative history. All citation. Los Angeles County Metropolitan Transportation Authority versus Alameda Produce Market, 2011. Case history. December 28, 2016, social worker Roger Rodriguez, came to the home and was allowed in. The kids were not home because mother was remodeling. Rodriguez made an appointment to return in 1 week to re-inspect after a remodel mess was cleaned up. After mother agreed, the very next day he showed up unannounced. Was still allowed to verify the kids were fine, and mother was on her way to drop off her oldest daughter to school, so she left. Rodriguez was upset he wasn't allowed in, and mother was upset he broke their contract of the 1 week later revisit. Following this, mother called the supervisor and left a message requesting a replacement social worker. Social worker Rodriguez was not replaced, and he continued to stalk and harass mother and refused to give any supervisors' email addresses. January 20th, social worker Rodriguez, using Sacramento Sheriff's Force, when the children were not home again, to gain entry into mother's home despite already confirming they were at her babysitter's. Actually, no one was inside, and they knew this. For a whole week, mother did not hear any replies from the department, could not get a solid answer for detention for her children, and sought police assistance just to be told, be careful, CPS is like the law. January 27th, at 8:30 p.m., social worker Rodriguez showed up with 3 sheriffs to serve a warrant they should have had a week prior. Mother tried to clear all allegations and clarify the claims with the Department of Sacramento. She had a new home to offer, and if the home condition was the problem, and if she was the problem, she'd give child care to her father. No resolution was accepted or even heard by the Sacramento County. The last hearing in Sacramento County, she was under the impression a trial would occur in Solano County upon transfer. A trial still has not occurred. Mother has been requesting formally and informally documents and evidence since before day 1. Now that she finally received evidence that proves the department lied about her hair follicle test, she is insisting, as she did from the start, for these heinous crimes against her family to be reversed once and for all. Parent has requested discovery since January 20th, 2017, and her first disclosure to facts was in the 342 petition given, where during her extraordinary writ of habeas corpus, the plaintiff has contacted Quest Diagnostics, I3 Screen MRO, and CDAT Drug Screening in Vallejo, requesting any and all paperwork pertaining to the hair follicle test done on child K. None of these companies would give the appellant any paperwork. She emailed the documents in question to them, showing her entitlement to such disclosure, including identification, including in-person requests and phone calls, and every company stopped responding after initial inquiry responses. Such evidence is material if there is a reasonable probability that, had the evidence been disclosed to the defense, the result of the proceeding would have been different. Citation of People v. Salazar. Okay. So we go into Brady. It talks about Brady disclosure, and the prosecutor, county counsel, whatever you want to call their attorney, and the investigators and the social workers are all on equal footing. So if the social worker doesn't give the attorney paperwork that is exculpatory, meaning it would be in your favor, they didn't disclose it to the court, the attorney is still held liable. So therefore, they have to be disclosed any and all, it's in their own interests to be disclosed any and all information pertaining to a case, because it's at their hands if it's not disclosed. So it's in their best interest too. So that's pretty much what Brady does. Talks about it being equal as far as disclosure on the prosecutor side. And so after the 366, in which the appellant was present, and the docket even states such, and the courtroom staff saw her as they exited the court hearing and upstairs at the clerk's office while papers were given to the guardians, she knew this court would require exterior factors to operate fairly. In the time between the 366.26, a redress of grievances, a third amended complaint, and visitation petitions in other children's cases were filed, with ill results in the family court for visitation, of course, Sacramento County. Excuse me. With ill results in family court for visitation due to this juvenile case, the appellant sought formal disclosure or dismissal of the juvenile case due to failure to disclose paperwork. All the efforts of the appellant were given to the trial court in the JV 180, and that same day the appellant received an email. The requested documents were ready. The addendum for the JV 180 motion to dismiss and introduces exculpatory evidence held by the department and the implications of this new evidence. According to the Quest Diagnostics, no test was done. This is clearly not what the department said. When they seized child K a second time, another piece of exculpatory evidence is an unaltered copy of results initially submitted to the court and received by the appellant for the first time during habeas corpus. Yeah, I only had one thing given to me during habeas corpus. Facts. 2 versions of one document exists. No facts follows the submission to Quest Diagnostics in the file that Quest requested to clarify what tests should be done. The MRO had questions and was not allowed to speak to the parents or caretaker. After 7 days, a claimed response was of a positive test, but actually the sample was discarded, as Quest Diagnostics said they would do if there was no reply received. No test is the last statement Quest makes in regards to this test. The court not only ignored these facts that exonerate the appellant's family, but it reasonably puts the department's claims altogether in question, which would justly call for a hearing of such new evidence. I reiterate the facts of both parents of child K. Drugs are not of a concern. Rodriguez of Sacramento lied about everything to the court. No parent has been seen with drugs or using drugs, with these pictures that do not exist of paraphernalia have ever been produced. Only pictures of a messy remodel while the kids were not home. The hair panel drug levels, if were true, should have caused immediate hospitalization if concern existed for child K, not days later, and filed during my courthouse protest, which was the Million Parent March of 2017. Another child's paperwork was received and served with the same dates of the hearing. If the court had fairly heard the appellant, she would have disclosed that she actually went to this child's home and talked to his mother. And this other child is the same age as child K and has medical issues. Had the court heard the appellant's argument, it would have realized this appeal and case could have been avoided completely, and would have ordered mediation as offered to the department's counsel prior via email. If an extension of a system cannot survive without cannibalizing itself economically, then amputation may be necessary for survival of that system, especially when inverse definition to action ratios are known by all actors of the system. Parents' unfitness needs to be clear and concise. Criminal charges are of a similar scope of accusation to prove, by preponderance, a liberally construed fact. When the intrusion is at such a scope to remove a child from a home. Harm to the child should be, in addition, of a physical nature requiring emergency, minimally urgent care. 4 days later, without seeing a doctor, or a warrant 7 days later, and a court allowing such hearsay is unacceptable. Proving parent unfitness first, before intrusion, is well argued and agreed to by the latest Texas Supreme Court amicus curiae, CJC. Although preponderance is the level of evidence must reach in the argument, contested evidence should be heard unless exigency exists and is provable with criminal or medical history beyond liberally construed hearsay facts. Although preponderance is the level of evidence you must reach in the argument, contested evidence should be heard unless exigency exists and is provable with criminal or medical history beyond liberally construed hearsay facts. The truth in this case is parents' liberty rights have been intruded upon as to literally search through drawers, fishing for a reason to seize child K. The Welfare and Institutions Code 24 states, provisions operational to extent not inflicting with federal law. When a reason couldn't be found, the department was forced to alter evidence to give cause for a removal petitioned for on September 6th, re-petitioned for on September 18th. Some arguments here do consist of evidence law in criminal matters, but the accusations in this quasi-criminal courtroom labeled as juvenile dependency uses liberally construed evidence to penalize a crime or potential of one, and sentence is of time withheld from the penumbrum of self. So quasi-criminal argument is relevant. In addition, the accusations that stem from social workers not only apply to a parent-child relationship, but they also extend to the community, your job, your relationships, and every other aspect of your personal life, and therefore should be treated with such care as if charged for a crime. Even in a civil matter, where the debate is financial or of a contractual nature, cross-examination is heard, and so is contested evidence. A good comparable to the parent-child penumbra of liberty rights would be marriage relationship between husband and wife. The parent-child relationship is in the penumbra of liberties without any difference of respect and boundaries expected from law as to live freely without government intrusion. This includes medical, educational, and religious decisions made by parents. America's greatest strength is diversity. It's crucial for sustainability. Individuals must be allowed to thrive without fear of exterior governmental intrusion. I will emphasize how important this matter is because a line has been crossed into the general population, the common people, by intrusive social workers who believe they are the law. The absurdity of details is to regurgitate trauma, to consciously and understandably comprehend what has happened to this family is simplistically explained as defined as un-American. The inability for an appellant to be heard is shown by the biased facts of the case and show good cause for any time beyond statute, rule, law, time limitations. Since 2017, the mother of child K has done everything a reasonable person would do in her situation. Ms. Peterson affirms the obligation to secure her children's home from this occurring again in the future. In the following redress of grievances, which was submitted to the FBI of Sacramento, Solano County, grand juries, and the Judicial Performance Committee in San Francisco, the occurrence of not being heard by the courts is thoroughly addressed. Even the motion to suppress evidence submitted to the appellant by the appellant was never responded to by the court. Nothing. The appellant has gotten responses as erroneous as "what the F is this?" by the clerk's office via email, rejection of certified mail, and not dismissing the lawyer to avoid service of hearings. The erosion of the legal protection of parents to raise, nurture, and educate their children without undue state interference, and about the unfortunate unintended consequences to innocent children caused by the routine overreach of the child welfare system. The United States Supreme Court has repeatedly held that parents have fundamental rights to direct the care, custody, and control of their children, most recently in Truxell and Granville. Yet parents continue to encounter obstacles in exercising these rights in schools, hospitals, and their community, and in the family court system. This case represents one of the most common occurrences of undue inference. Court-imposed changes in custody and visitation without first determining the fitness of parents. And then I go into more legal argument, which a lot of it was written by parent advocate group, parents advocates, something. I guess I should quote that right, because the whole next section is them with all the different states and arguments. And they won, I think it was Texas, but the Supreme Court continues to deny hearing these cases, and now we know why, don't we? Okay, bye.